A provisional application is never formally examined. So what it is basically a technical disclosure of your invention, and it can be, there's no requirement that it have anything. I've seen provisionals that were basically scrawled on the back of a napkin.
Okay.
The patent office will never look at it. It will get filed. You have a year from your first filing date of that provisional application in order to file a utility application to have it mean anything. If you don't do anything, if you don't file something within a year that claims priority back to the provisional just goes away like it never happened.
Okay.
It goes off to, I envision it getting put in one of those crates that you see them wheeling off at the end of Raiders of the Lost Ark. It goes off into the warehouse and nobody ever sees it again. Probably doesn't happen anymore. It probably just goes to some dark corner of the internet, of the patent office's intranet, and never gets seen. But that said, while you can file something that's very scant as a provisional application, there's a risk, because in order to, like I said, the patent office will probably not look at your provisional application. In some instances, I've seen examiners look at the provisional application if they find intervening prior art. So say you filed a provisional application today, or say May 1st of 2016, and then you didn't file your utility application until May 1st of 2017. But maybe there's somebody else published something 6 months from now, which, if you were entitled to the priority date of your provisional application, would not be prior art. You predated it. However, if your provisional application is so vague or lacks the details necessary to write a claim that's actually allowable, and if somebody could argue that, you didn't really describe what you're claiming here in the utility application until you filed it, that prior art that was intervening could actually come and get you.
Okay.
So I usually recommend, it's certainly, we can take just some technical document that an inventor gives us and just file it as is. I usually don't recommend that.
Okay.
Just because it helps to at least take one pass through. Let's have a conversation about what we think we're going to claim and what we think the important things are. And let's make sure that we at least have description around that.
Okay.
Typically when somebody gives you a disclosure, it's very easy to describe sort of the problem. Or, here I can give you a whole, chapter and a half on what we do.
Yeah.
So, but where's the interesting stuff? You need really the details around the stuff that your secret sauce, what makes you new and different.
Okay.
Otherwise, you run the risk that when you write your application later, it may not be entitled to that earlier